shining a light where the shadows creep, for the lost, the stolen, the ones who will weep. She won't turn away, she won't back down, even when the loony clowns come round. Threats don't shake her, lies don't win. She stands for justice, right till the end. Want the truth, want the best, wanna be safe as you chat. Find kids true crimes, worth your time. She's got your back, she's on the line. YouTube, Twitter, TikTok too, Facebook stream, she'll fight for you. Chase fame, some chase views, but she fights for those with nothing to lose. For the kids who vanish without a trace, she won't stop till she cracks the case. They try to silence, they try to scare, but truth don't break and she's still there, calling out monsters, showing their game. Justice comes when you speak their name. Want the truth, want the best, wanna be safe as you chat. Find kid true crime, it's worth your time. She's got your back, she's on the line. YouTube, Twitter, TikTok too, Facebook stream, she'll fight for you. Need a voice, kids stand strong. She makes the choice for victims gone, for those in need. She's fighting hard, she won't concede. Want the truth, want the best, wanna be safe as you chat. Find kids true crime, worth your time. She's got your back, she's on the line. YouTube, Twitter, TikTok too, Facebook streams, she'll fight for you. At the end of the day, this is all we have to say. Viper will always have her back. He will kick you right in the sack.
They're calling me a wave wife? Are they? Oh, that's too funny. Talking shit about you. They say you're a Wade's wife. Small, is that the name of it? Oh my God. Are they effing crazy? Hold on a minute. Where do I gotta go? I'll go there right now. Yeah, they are stupid. I already told everybody what I said. Okay, See, I don't worry about these people because I know my hold on a minute, but I do want to see. I want to hold on, I gotta take a picture here and go there. Oh. All right, I'm gonna go look. Hold on, people. I'm quick. People, I'm not even worried about it. However, I will call people out for talking about me, though. That I will do. Okay, shit. Small. energy. All right, hold on. Let's look. We're going to look, people. We are going to look. You know what? I think it's funny. I'm not concerned. Okay. You want to know why? Because I didn't say anything that I would be worried about. Dang right I did. I wanted to know what his she didn't want a romantic. Oh God, no. All right, hold on. We're gonna look, people. We are going to look. I have no problem looking. Mm-mm-mm. Who's that? $18 ago. Does somebody want to send it to me so I could tell you if it's me or not? I don't know. Can somebody send it to me to my email? If not my email, DM me on Facebook. Is it pretty new? Not down. Okay, hold on. Bear with me, people. Oh, that ain't me. Hold on a minute. All right, hold on. I'm gonna find it. Hold on, hold on. Nobody's gonna sit there and talk shit about me. When you don't even know what you're talking about, because this ain't me. I'm looking at it right now. Hold on. I want to bring it up so everybody can see it. Hold on. Hold on. And whoever this person is, why don't you come over here? Let's have a conversation. Why can't I find it? Can someone explain to me? Hi. Hi. Hey, girl. I want to say hi to everybody here. There's a situation I need to take care of. Okay? Big difference between. I don't have to explain myself to nobody. However, I told people in June, you dumbasses. Just saying. Just saying. I don't know why this won't come up. I read it. You know what? I'm going to read it out loud. It says here. Hold on a minute. $6 ago? Oh, this is strange. They're not in order. Hold on. Maybe I have to go down further. Go get that person. Somebody tell them to get their ass over here right now. Listen to me. Tell them to get over here. Oh, funny. None of this is me. Dumbasses. All right. 10 days ago, 26 days ago. Okay, this. Oh, somebody, they're talking crap about me. I know you text me the link. Hold on a minute. Let me do it differently. Who's Jaded Preparation 34? Hold on a minute. Oh, this. What are you people doing? This is not me. Dummies. Wow. Can someone explain to me? Sorry, guys. This is crazy. No, they're talking smack. That's okay. Bring it on. Get over here. Let's have a conversation. Because you know what? It is not me. That is not me. Nope. Hey, Jaded Preparation, why don't you come here? I'm trying to figure out how to pull it up here because I'm looking on my phone. I have no idea. Okay, I'm not going to worry about these fools. But I do want to say, I don't even care if these people watch me again or not, okay, because they're not important to me. And I can contact any inmate I feel like it and ask any kind of questions that I want to and talk to them about whatever I want. It's none of your business. You got it? Good. Well, of course they're hiding. Of course they're hiding. I dare them. I dare them. All right, everybody. Okay, Lord Vallow. There's some new documents. I'm not even worried about these fools. But I looked there too. So let me repeat. I'm going to talk to whoever I want, whatever inmate I want, and it's none of your business. All right? And I'm not even going to mess with you fools. All right, here we go. So this here, Lori, is, oh, hold on, let me bring up my, Okay, I have to bring up my chat. There we go. I got you all. It says here, motion to dismiss violation of confidential communication and the Sixth Amendment. Okay, defendant Lori Vallow hereby requests that the court order dismissal of both cases and sanction to the MCAO. The state is in possession of attorney-client privilege text messages, communication of another state, which federal violations are upheld. Okay. MCSO Estrella facility administration illegally obtained and provided attorney-client privilege. Hold on a minute. Let's go to number 2. All right. Message communication to the MCAO. Federal law requires that sanctions are imposed for, what is that? Remedial action of automatic dismissal for cases in judgment of acquittal, which a defendant is requesting. The defendant will show just what cause to warrant. Hold on, I gotta turn off my notifications. Oh my God. Because I haven't been around for 4 days. It's like starting all over again. All right. Okay. The defendant will show just cause. Okay. Facts. Here are the facts, people. Oh, look who's in here. You know what? I don't think it's any of your business. You have no idea. I have been around for 6 years. I talk to whoever I want. Okay. And I've done a live. And you know what? Gamma's mom has no problem with me. So there's that. Why don't you come on panel? Am I friends with Letitia? No. Why would you say that? Yeah, I wrote with Letitia. You guys have no idea. All you people are so new. You have no idea. The conversations with me and Letitia, because I shared everything that me and Letitia talked about. Who had what? What is going on here? I'm lost. What's going on in the chat? Is everybody okay? Oh. Okay. No, I didn't. Oh, never mind. I'm like, what? Because they're part of Wade Wilson, and they have no idea about the situation with me. They have no idea, and that's why I don't share who I talk to. Okay? I don't share who I talk to. Okay? A lot of high-profile people. Okay? And I ask questions about their crime and about them and how they got to where they are. And you know what? And I don't care. I really don't care. Oh, of course, my calls remain. Everything should be up. Everything should be up. Go under Letitia. Hold on a minute. Oh, I think I know what you're talking about because Jesse made me lose my channel. So all those lives I did with everything is gone. So everybody can thank Jesse for that. Hold on a minute. I'm going to find it. Everything for you. Oh, let's talk a smack about. Oh, come on. Shut up. You people are stupid. Whatever, you fool. I'm not worried about any of you. All right, hold on a minute. I gotta find it. All right, Letitia. Hold on, I'm trying to find the list. All right. All right. I don't think it's none of your damn business. I want to get the hell out of here. You're going to be all rude to me? You can get out of my chat. All right, here we go. Hold on. There you go. There's my list. There's my playlist. And if you go look in the Facebook groups, you'll find my phone calls, my letters, which I have them here too. Okay? Which I have them here. So don't even tell me any of this is on private because it's not. It's all right here. You just got to look a little harder. A little harder. Why don't you go look? Why don't you go look? You don't have Facebook? I don't care. They can call me a Wade's wife because they're fools. Who are you? Who are you? Why don't you come up here? Okay, let's continue. But if anybody wants to come up here, come on up here. Okay, Lori Vallow. Okay, where are we? Federal law requires sanctions. Okay, facts. The defendant was extradited from the state of Idaho, where she will be returned to finish her sentence. The state of Arizona is temporarily in possession of the defendant pending trial. The state of Arizona has no jurisdiction enforcing the state of Idaho laws or federal laws in another state. To whom would she obtained and prosecuted the defendant? Okay, hold on. Okay, the state of Idaho upholds state and federal laws protecting attorney-client privilege, as well as confidentiality and communication. This includes text messages between the defendant and her appeals lawyer in Idaho, and such violation constitutes breach of duty by the MCAO. Hold on a minute. I'm not a StreamYard. Answer the question. That would be quicker than having people come. I did answer. No. Okay, where are we? Since neither can employ Idaho laws in Arizona, therefore it is a violation of the state of Idaho and federal laws. Let's see, where am I? Federal laws listed above. The defendant in its appeals process in Idaho, the legally obtained text messages between Craig Durham and the defendant are specific to work product and are federally protected in appeals court and federal court. Its contents include, but not are limited to, defense opinions, theories, strategies. The agreement of both states was to preserve the defendant due process, constitutional fundamental rights. And she says that they violated them. Hold on, because these are not in order. All right. All right. By providing the ACAO, the confidential communication between Idaho appellate attorney and the defendant, depriving the defendant's constitutional right to her appeal her convictions. MCSO violated all the above by submission of the confidential communications to the court, creating multiple violations to the state of Idaho federal laws and the defendant's constitutional rights. The defendant's right to an appeal has been compromised because the text messages refer to her legal defense. The appeals court has no other remedy process but to dismiss the defendant's case for violations directly related to illegally obtaining attorney-client privilege, confidential communication by both state of Arizona and Idaho. How did they get that? Hold on a minute. Are they bothering you? Yeah, get on the panel. Actually, nothing came to light because I've talked about it, fool. I'm not calling you a fool. I'm not calling you a fool. I'm calling these people that are coming in here with this nonsense. Okay. Evidence obtained through intercepting messages by a government agency are admissible because of the mode of obtaining is unethical. The rules of evidence in criminal cases in court of the U.S. sitting there constitutionally are those of common law. Common law rule states the miscibility of evidence is not affected by the legality of means by which it is obtained. Every person who shall intercept, read, or in any manner intercept or delay the sending of the messages shall be guilty. The 18th Amendment has not in terms empowered Congress to authorize anyone to violate the criminal laws. The state nor MCSO have been granted authority to obtain the communication records or text messages through judicial process, therefore violating Brady law. The federal law prevents both parties from obtaining a substance subpoena, order, and a warrant. Okay, let's go to full. Where is 4? Hold on, guys. Okay, there's 5. Okay, here's 4. Oh, did I read this one, you guys? No. It's good. Don't let them bother you. It's okay. See, if anybody knew my main channel before Jesse had it taken from me, you would have known that because I told everybody that in June. Yeah. And there's other people I contact. People know all about Letitia. Okay. And it's my business to talk to whoever I want. You guys would never find out any information if I didn't do otherwise. And I gave a lot of people content. Let me tell you that much. And just so I'll say it again, me and Gannon's mom are cool, so don't even try to go there. Consent to the attorney, client confidentiality, communication privilege of another state, especially attorney, appeals attorney, MCSO and MCAO agreed this privilege would remain intact for temporary custody of the Idaho inmate, Ms. Daybell. The state provided the courts with intent and knowingly breached the interstate agreement contract, but breached both Idaho and Arizona. Okay. The violations of both have compromised the integrity of the cases in Arizona and the appeals court in Idaho. The U.S. Supreme Court can and will dismiss or acquit the defendant in both cases. Is that true, you guys? What do you think? I think maybe they're Brady violations. I know in Idaho, the only way that, well, I don't know. See, MCS or the DA's attorney, I know this. Idaho don't like to give any information. Okay. You can't get any kind of documents. You can't get any phone calls from Idaho. You have to have a subpoena to get any phone calls, any Lori's phone calls. All right. Let's see. Continue to violate the state and federal. Let's see. by illegally obtaining, creating fruit of poisonous tree doctrine violation. What is that? And Brady violation. The violation should be attached to the courts that allowed the above parties to submit the legally obtained records, knowing that the court never granted or awarded the state to obtain such records through an order, warrant, summons, subpoena, contest. See, that's the only way you can get this stuff, you guys. The court is aware for the breach, anything, that's what I'm saying, anything from Idaho. The breach of the federal laws and to the laws of Idaho protecting client attorney communication and privilege by allowing the submission to occur. Thus, violation of confidential communication with attorney work product cannot be compelled as shown above. So let's see, they go with the case law, and it says dismiss state's indictments claim by MSSO had violated defendant's rights. So let's go to page 5. All right. Ooh. Under the 5th and 4th Amendments of the U.S. Constitution, and then they give it case law. MCSO illegally obtained the defendant's text messages, opened the legal mail of the defendant. Oh, that is a big deal. Deliberately and not in the presence of the defendant. Uh-oh. And the text messages and confidential communication fall under attorney-client confidentiality and communications privilege. Was submitted by the state to the courts of evidence. Once the state reviewed the text messages provided by MCSO, both parties should have sought an in-camera review. Wow. Neither MCSO or MCAO adhered to the standard judicial process. Neither party had in their possession a subpoena, warrant, order, consent, or summons to obtain the client attorney privilege, material, or work product, which cannot be compelled under, and then they give the law, case law. Many of the intrusions are deliberate, calculated, and occurred while in custody. Motive behind these instances is to deprive the defendant and illegally assist MCAO in inclusion. Where am I? Their assumptions was to mislead, represent, and deceive the public, the court, and the defendant, that MCAO and MCSO complied with state and federal laws and seizure, overlooking the fact that both parties breach. And then it gives the federal law. Let's see, State versus Warner. Thus, the defendant's rights included protection from improper instructions, state and local government. You know what? I wonder if they're going to be having a hearing on this. Interfere with confidential attorney-client communications, has a risk of disclosure of confidential info. Wow. Has anybody seen any of this? I just got home today. I haven't been around for 4 days. Yeah, I wonder what's going to happen here, because there's some huge violations here. However, that judge in Arizona, he knows what he's doing. You haven't seen any of it? Okay. Hold on. I'm sorry. Let's make that bigger. All right. Okay, based on the state submitted by the court, the attorney-client privilege, confidential communications, they are now public record. Are they? The state comprised or compromised the defendant's appeal in Idaho, breaching and violating state and federal laws in the intersection. Conclusion. Wow. The state of Idaho has public access to the submission by the state of Arizona. And the appeal strategy, defense, opinion, memorandum, and the communication of the defendant. Furthermore, the state and MCSO have not provided the subpoena to obtain the defendant's text messages. See, I told you guys that. Idaho is huge on that. The MCSO, the Global Tel Link, argues that texts are not privileged, and they're not. They're not in Idaho. Defendant contests that her communication obtained are privileged, citing texts turned over to the defense on February 6, 2025, between defendant and Idaho attorney. In fact, they are privileged communication. Because Attorney Craig legally represents the defendant in her appeal, the defendant and her appeal attorney had made reasonable efforts to secure private and confidential communications to meet the expectations of the process to continue her appeal. You know what? I thought her appeal was on hold. And I'm really shocked that they let her go to Arizona because she just got done with her trial. I thought they would have to wait for the appeal. I don't know. It's agreement they have, whatever. The defendant and her legal defense believe that all attorney-client communications are privileged and protected under the federal rules of law. The defendant has not waived or replenished her attorney-client privilege to Craig Durham. I've never heard of that guy. Okay, that's 7. Let's go to page 8. All right. Exhibit A is communication emails. Okay, they're not going to show that, which I don't really care to. From MCSO to appellate attorney. At the time, attorney Craig Durham received this email confirmation from MCSO that his communication with the client would now be privileged. Defendant then assumed this or presumed the same. Exhibit A shows the extended timeline in which the appellate attorney had no access to communicate with defendant to work on her appeal. The attorney-client privilege is derived from the defendant's constitutional right of due process. Okay, they're talking about case law here. The privilege of the essential function of communication between attorney and client, unless the attorney knows the truth. He or she cannot be assistance to the client. If the accused is to derive the full benefits of the right to counsel, she must have the assurance of confidentiality and privacy of communications with her attorney. The attorney-client privilege is paramount. And then it gives case law of the criminal actions. All right. The work product privilege prohibits discovery of written statements, private and personal recollections prepared or formed by counsel in the course of legal representation. When a client's consent is not provided, the attorney may not disclose communication with the client without legal representation. Okay, we're almost done here, guys. The prominent of the privilege would show that there's an attorney-client privilege or relationship. The communications were made to secure and provide legal advice. The communication was made in confidence. The communication was treated as confidential. The attorney-client privilege extends as member of Daybell's defense team, including her investigator, Jeff White, her paralegal, Idaho attorney for appeals, advisory. The Clemens element is to establish privilege that may be satisfied are the three remaining elements. The communication was made secure, provided legal advice in confidence, and was treated as confidential. The defendant established a legal account on the tablet, which she texts members of her defense team on January 31st, 2025. Defendant Advisory Council received an email from the state containing all the defendant's text messages from MCSO. Date range from 10/24/24 to 1/24/25. Oh, wow. Wow. The text messages contain attorney-client privilege communications. The defendant, Lori Vallow, now they changed it to Lori Vallow, and the appellate attorney, Craig Durham. Okay, on February 4th, and again on the 13th, legal mail addressed to the defendant from the MCAO was delivered to the defendant previously opened by the MCSO staff, not in the presence of the defendant. Again, the legal mail was previously opened, not in the presence of defendant, and then slid under her cell door. You know what, guys? They're going to be in trouble. They are going to be in trouble. Hold on. All right. In the middle of the night, on February 15th at 10:30 a.m., defendant's investigator arrived to MCSO and was sent away being told he could not meet with the defendant that day, although he had an important time-sensitive document to deliver to her on Monday the 24th at approximately 5:45. The administration STR was sent to defendant's cell to search. For a search, the defendant's legal documents were searched by SRT outside her presence. There is body cam footage and pod video surveillance. Wow, we're never going to get to see that, guys. Let's see, where am I? Surveillance that will confirm that the defendant was told to leave her cell, go downstairs during the search due to the fact the defendant has hundreds of legal documents and thousands of pages more of discovery. It is undetermined which documents were seized. The defendant was asked by SRT to look into her cell and identify immediately if any legal documents were missing after they performed their search. This was impossible. Okay, where's the proof? Okay. On the 24th, legal mail from the defendant appellate attorney in Idaho was again opened by the MCSO staff, and it was another one was open and slid under the defendant's cell door in the middle of the night instead of it being open in her presence. On March 6th and the 12th, legal mail was handed to defendant previously opened, not in the presence of her. Oh boy. All right. Legal mail being opened without her presence, the officer stated that the legal mail was open prior to him receiving and delivering it to defendant. This is an ongoing issue. Clearly, MCSO is not following their own policies and procedures when it comes to this particular defendant inmate and how staff should be handling and delivering her legal mail. In conclusion, the state and MCSO have violated so many of defendant's constitutional rights. The state and the MCSO should receive sanctions for these violations. They will. That I know they will, but they're not gonna. They're not gonna. They're not going to dismiss. Nope. Nope. They won't. Okay, and I want to show you guys this right here real quick. Hold on. Okay, this is Lori. We're not going to play the whole thing. We'll probably just. All right, so here we go. This is Lori Vallow got incident report that I got from the jail. Hold on, let me. There you go. All right, good morning. We've got an incident report with Lori Vallow. Let's get to it. It's going to be real quick. All right, this happened. Let's see. 2/18/2025, discipline action report printout. Lori Noreen Daybell. And let's see. Okay, date, time of violation. Oh, that's weird. 2/21/24 at 4:35. That would be a.m. Formal statement. On 2/20 at approximately 2245, Officer Door A9957 asked inmate Vallow what size clothes she needed for court on 2/21/24 at 0345 hours. Officer Door woke up inmate Vallow to get ready for court. Inmate Vallow stated that her lawyer told her she didn't need to appear, or she didn't have to appear, sorry. She was advised that she would receive a write-up if she refused to go, which we know she did. Let's see. I don't think she got an discipline. No actions. No actions. No actions. And she did sign in. So what we're going to do, because I remember this day, I'm going to play you guys the day of court that she didn't show up, which I thought is funny. You want to know why? Because her attorney said she wouldn't show up. But here she says her attorney said she didn't have to. So I don't know. I don't know who's telling the truth and who's lying.
Fairness, respect, and dignity, to a speedy trial, to be present at court proceedings, to choose whether or not to be interviewed by the defendant or the defendant's attorney, to be heard before the court makes a decision on release, negotiation of a plea, scheduling, and sentencing, and to receive restitution from a person who is convicted of causing you loss. If you have not already been provided with a written statement of all victims' rights, please contact the Victim Services Division of the Prosecutor's Office. We're going to go on the record now in calendars number 1 and 2. This is CR 2021-001-704-001 and CR 2022-001-242-001 in the matters of the state of Arizona versus Lori Vallow. May have appearances.
Katie Staub appearing for the state, and I would note that next of kin are present online.
Thank you.
Good morning, Your Honor. Pamela Hicks, Robert Abernathy, Megan Swart, on behalf of Ms. Lori Vallow, who's not present. It's my understanding she refused.
All right. The court will waive the defendant's appearance for purposes of today's hearing only.
All right, did you hear that? So Lori told them that her attorney said she didn't have to come to court this day, and now her attorney says otherwise. But it really, honestly, wasn't a big deal because it talked about her rule 14 or whatever. Hi, KB, how you doing? How's your meet and greet go? Oh, have you guys decided what movie you want to watch for tomorrow. Because remember, we're not doing it on Rumble. Because people like to be like little children and go tattletale and get my stuff taken down. Okay? So we're going to do it in StreamYard like we've done before, but we don't go live. But man, my blood is boiling with it. I don't know, man. That's why I just don't do with these people because they have no idea about true crime and about these people. They're just learning about certain inmates or people that have committed horrible crimes, right? So they don't know. They don't know what's been talked about, what's been said. They know nothing. Just the people that were here in 2019 know. You know what? I'm trying to think, but remember, Misty, we are going to do, because I'll get a 7-day free pass, but it's 6 hours long. Well, it's a total of 6 hours altogether of all the mafia, the top five mafia, and that's the Gambinos, Columbos. Oh God, who else? Oh God, I used to know them all by heart. But if you can think of any movies, can you let me know? And then tomorrow I will show trailers and we can decide from there, I guess, in the morning. How does that sound? And Misty, I want to thank you for having my back. You know I can handle my shit, but I mean, come on now. Yeah, I did ask them to come in here. I sure did. But not when you come in all rude like that and telling me what to do and what I should do. You don't do that. You just don't do that. These people are not even creators. And you know what? Actually, I don't have to tell anybody a damn thing. But I do. I can't think either. Yeah, they don't know me though. They don't know me. Yeah. Well, if you see nobody came on panel, I mean, I'll sit there. Yeah, I'll argue with them on chat, but when it comes to a panel, I can be cool on a panel. Just like that girl that came in here the other day about Bobby. How she came in here all sideways when she doesn't even know the research we've done. No, they don't, do they? See, that case is so dark, and the Wade Wilson case is so dark and toxic. It's unreal because the people are crazy. Dang right she was. I've never seen her before. Nobody's ever seen her before. You know what? I think she's a friend of Bobby's, huh? But I let Miss Barbara handle it. You know what I mean? Because she's the one that's hurting. Her son is the one that's gotten no justice. Okay. What? I heard from another content creator that you're being talked about. Oh, I don't even care. Yeah, she sure did. Okay, I got to get going. I got to go get Nala at 8 o'clock. But I want to thank you guys for coming through. Just thank you for having my back. Don't worry about it. The people that know, okay? So don't even worry about it. She sure did, didn't she? Love you too. All right, guys. I'll come again live tomorrow if I think of any shows. And if you do, let me know, okay? You guys know how to get a hold of me. Goodbye. Good night. Love you.